Are you facing redundancy? What should you do if you are? We've invited Mr. Sundeep Bhatia, who has been practicing law for the last 28 years, and he is an expert in employment law. So Sundeep, welcome. First, let's explain what's redundancy.
Redundancy is when the type of work that an employer is doing or is doing at a particular site diminishes, or the type of work that the employee does, there's less of a need for it, and therefore the employer seeks to thin out the workforce by making some of the employees redundant. In other words, they lose their job.
How should an employer select an employee for redundancy?
Well, it's very important that there is a fair selection process that is gone through, which involves consultation with employees and seeing if there are opportunities to redeploy them or give them alternative employment. And employers, at the very least, should sit down with employees to see what their views are and if they can come up with any suggestions about how to keep their jobs. Now, in the case of larger firms, if there are going to be 20 redundancies over a 90-day period at a particular establishment, then they have a duty in law to consult and to get trade unions involved and to inform government that those consultations are taking place. So there's a far more formal procedure. There are more employees that are being potentially made redundant. But an employer needs to go through those procedures in a fair manner, because otherwise, if an employee questions their selection for redundancy and takes the matter to a tribunal, one of the things that the tribunal will look into is, was there a fair procedure gone through before that decision was made to make that particular employee redundant?
How long should an employer consult his employee for redundancy?
It depends on the size of the organization. Obviously, if you're talking about a small office with a few employees, it's not going to take that longer period of time. But if it's the scenario I laid out, 20 people in 90 days, it's a bigger organization and they've got to consult properly over a period of time. So it's obviously going to take a lot longer, and it's expected to take a lot longer.
Do they have a statutory right to have someone with them during the meeting?
I don't think they would have a statutory right to do that. A good employer might feel that it's a good idea for their employees to have someone with them while they have that kind of discussion, if it means that the discussion is going to take place in a friendlier and more open way.
Say an employee got redundant now. In the future, can the employer hire somebody else for the same job?
No, I would argue that that would be what's called a process of bumping, because what you're doing is, if you get rid of somebody and then you immediately put someone else in their place doing the same job because they're cheaper or because potentially they're better, then that employee who's been made redundant would have a very good argument that they'd been unfairly dismissed.
For example, there are two employees who are working for the same job, one in a full-time and one on a part-time basis. Now, is it possible for the employer to redundant the full-time employee and continue with the part-time employee for the same job role?
An employer has to be very careful not to discriminate against somebody on the basis of them working part-time. So there'd have to be a difficult decision there. But if they're doing the same job, I suppose it depends on the scenario for the individual business, which is something which would be subject to independently, individual legal consultation.
Can the employer argue the fact that they were in trouble? Now the company business is back, so can they resurface those jobs back, and can they go and hire someone else for those roles?
Well, I imagine that there would be a gap, a time gap between those two scenarios. And if a business could show that it had genuinely gone down at a particular period of time, had to get rid of employees, but then some months later the situation improves, then I think we could probably say, number one is that an employee only has a certain amount of time to bring a claim at an employment tribunal and they may well be out of time. And secondly, that business would probably be able to show that there was a general downturn, which meant they had to make people redundant, but that things are coming up, and they could therefore probably justify the decision that had been made when things were on a downward curve.
Is there any legal binding when those jobs resurfaces? The employer has to offer those jobs to the previous employee first.
Where that really applies, if somebody's been on statutory maternity pay and comes back, there's more of a duty on the employer to look for a position, to offer that position to that person who's come back from statutory maternity leave, and they should have first call on any jobs that are going.
Thank you, Sundeep. Well, is there anything else we need to know?
About redundancy, obviously, if somebody's unhappy with their selection for redundancy, they can raise a grievance, which we've covered which we're covering in another one of these talks, and you can look at that procedure and go through that procedure if you want to complain about the fact that you have been made redundant.
Thank you, Sundeep, for sharing your knowledge. My name is Gunjan Hazarika. I'm a television producer and a director. My mission is to seek answers to your questions. Right now, we're going through some unprecedented times, and it's a time where knowledge and information will be the key. We'll be creating a lot of videos which we believe will be important to you. So all you have to do is ask those questions, and we will seek the answers. So please kindly share this video or put up a like and let your friends and family know that this platform exists for you. This is your right. This is the platform. So let's connect.